Good afternoon. May it please the court. My name is Aubrey Greer with the law firm of Glencla Brown in Memphis, Tennessee. I, along with my co-counsel Robert Myers and Danielle Rasoul, represent the plaintiff appellant in the matter before the court today. At this time, I would like to go ahead and reserve 4 minutes for rebuttal, please.
4 minutes.
This case arises from a petition filed in the Shelby County Circuit Court to remove the defendant appellee, Ms. Wanda Halbert, from her current role as the county clerk for Shelby County, Tennessee, pursuant to Tennessee's written ouster statutes. Now, the matter before the court today has nothing to do with the underlying merits of the case. Rather, the court is presented with the dispute regarding whether or not the circuit court correctly interpreted and applied the ouster statutes as written, as applied to the facts of this case. On March 14th, 2025, the Shelby County Circuit Court issued an order granting defendants' motion to dismiss the petition based on a lack of subject matter jurisdiction. The trial court concluded that the appellant lacked the standing to bring the claim and that the trial court itself lacked subject matter jurisdiction to hear and decide the dispute. Now, the trial court's decision in this regard was error and it should be reversed ostensibly for 2 reasons. First of all, the county attorney for Shelby County, Tennessee absolutely had standing to bring the case. Second, the circuit court clearly had subject matter jurisdiction to hear and decide the case. Both of these issues are resolved by simply looking at the ouster statutes themselves. Now, the question of whether subject matter jurisdiction is, at least in formulating the basic question, whether or not a court has the ability to hear and decide a particular dispute. Now, that jurisdiction is either prescribed by a constitutional provision or by a statute. Here, the ouster statutes provide us that guidance. Section 103, Tennessee Code 8-47-103, requires that suit be brought in, quote, the circuit, chancery, or criminal court of the proper county to oust such officer from office. Here, because this is a case to oust a Shelby County official, the Shelby County Circuit Court is clearly vested with subject matter jurisdiction to hear and decide this case pursuant to the ouster statutes. Thus, as it pertains to merely whether or not the circuit court can hear the case, can decide the case, the statutes are clear. The answer is absolutely yes. As it pertains to standing, at the risk of oversimplifying it, the issue of standing really just asks, is the plaintiff the proper person to bring this claim? Do they have the right to bring this claim? As with the issue of subject matter jurisdiction, the issue of standing, again, we just need to look at the ouster statutes. And the issue of who has the ability to bring the claim, who's the proper person to bring the claim, is recited over and over throughout the statutes in many places. In fact, Section 102 is aptly named who may institute. And Section 102 says, and I quote, the district attorneys general, county attorneys, and city attorneys within their respective jurisdictions may institute such actions without complaint being made to them or request made of them, as they are authorized to institute upon request made of them or complaint made upon them. Section 103 goes on to say that it's not just who may bring it, it's actually the duty of these people to bring these claims. It's the duty of the attorney general, the district attorneys, the county attorneys, and the city attorneys to bring ouster suits when they receive information that may give rise to an ouster action. And Section 110 of the code provides that all petitions in ouster must be made in the name of the state of Tennessee and upon relation of one of those enumerated parties. Again, the attorney general, district attorney, county attorney, or city attorney, depending on the identity of the person to be removed from office. Here we have a county official. The county attorney is the proper person to bring that suit in the name of the state of Tennessee. As such, the ouster statutes clearly contemplate in this context that the Shelby County attorney is the proper person to bring a suit to remove a Shelby County official. Thus, as it pertains to whether or not the county attorney had standing, again, the statutes are very clear. The answer to that is yes. Now, while the trial court appeared to acknowledge that all things being equal, the various provisions of the ouster statutes would seem to resolve the issue of subject matter jurisdiction and the related standing issue, the trial court nonetheless concluded that the appellant lacks standing to bring the suit, and the court lacks subject matter jurisdiction to hear and decide the case. The trial court appears to have premised its argument, or its decision rather, on the conclusion that in the original petition, the county attorney for Shelby County, Tennessee, Marlinee Iverson, disclosed that she may have a potential conflict of interest. And as such, and out of an abundance of caution to ensure that there was no prejudice to Ms. Halbert, the defendant, the county turned over the actual prosecution of the case to independent outside legal counsel, my law firm, Glencla Brown, Aubrey Greer, Robert Myers, Danielle Russell. The trial court concluded that because the county attorney wasn't personally involved in every facet of the case, that somehow deprived the county attorney of standing and robbed the court of subject matter jurisdiction. Now, this simply isn't the case. And there's really two ways to look at this issue, and frankly, in either way you analyze the question, both of the outcomes favor the appellant in this case. Now, there could be this viewpoint that issues involving potential conflict of interest are subordinated, not necessarily displaced, not necessarily preempted, but are subordinated to the requirements of the ouster statute, meaning that traditional issues impacting attorney representation, like conflict of interest, may play a lesser role under the ouster statutes. After all, county attorneys, just like other government officials throughout Tennessee, they are the chief legal officers for their respective jurisdiction. In that capacity as the chief legal officer, they frequently interact with the other county offices, county departments, employees, officers, elected officials. They routinely offer advice, answer questions. When there's litigation, whether on the plaintiff side or on the defendant side, the county attorney provides representation to these various departments and agencies and officers. Thus, under the ouster statutes, a county attorney is almost always going to be in a position where there is some prior relationship. There's the accrual of knowledge. There is perhaps retention of confidential information. That's almost always going to arise under sets of circumstances like this. And the General Assembly surely had to know that. And in fact, the rules of professional conduct seem to contemplate this sort of scenario and counsel that while the rules of professional conduct governing lawyers are important, they need to be flexible when dealing with government lawyers. And thus, if we're in a case where the traditional rules of professional conduct are ameliorated, displaced, subordinated to the ouster statutes, then what we have here is the county attorney in Shelby County, notwithstanding her concern about a potential conflict of interest, absolutely had the right to not only bring the case, but to personally participate in the case, which means we really don't have an issue here. The only issue that would remain was whether or not outside legal counsel, again, my law firm, could participate in the suit. But that would be an attorney disqualification issue. That really wouldn't go to whether or not the circuit court can hear and decide the case, whether it has the ability to adjudicate the dispute. And as we cited in our brief, there is some precedent that supports this notion. The case of State of Tennessee, Exral Estep versus Peters, 815 Southwest 2nd, 161, Tennessee Supreme Court case from 1991, seems to contemplate this. In that case, the Claiborne County attorney sought to remove a school superintendent. The jury returned a verdict in favor of ouster. The superintendent appealed, and one of the things the superintendent complained about was the fact that the Claiborne County attorney was participating in the lawsuit. There was a potential confidentiality issue, and potential prejudice could result. The Supreme Court ultimately disagreed, and the Supreme Court recognized that a county attorney's participation in an ouster case amounted to, quote, little, if any more, than the use of his title, county attorney, as is appropriate under the ouster statutes. The other way to look at this is if the ouster statutes don't completely displace the traditional rules of professional conduct relating to conflict of interest, then there must be some sort of procedure to deal with cases like this. Again, under the ouster statutes, it is the affirmative duty of the county attorneys, city attorneys, attorneys general to bring these types of suit when they're brought specific information. It's not discretionary to them. The statute says shall. So the question becomes, what's the process? What's the process when somebody like a county attorney receives information that may give rise to an ouster action? But again, we've got this relationship between the county attorney and the person to be ousted that raises a potential conflict of interest issue. And the answer is exactly what was done here. While the ouster statutes require that the county attorney bring the suit in the name of the state of Tennessee, the statutes don't actually require that the county attorney participate in every facet of the case. The county attorney is the named party. The law is flexible enough to account for circumstances like those presented here and allows for independent counsel to be appointed, to be hired to prosecute these cases. And in fact, this court decided a case, State of Tennessee ex-rel Commissioner of Transport versus Medicine Bird Black Bear White Eagle, 63 Southwest 3rd 734, 2001 case. There, this court was talking about some of these issues, and it was a case that dealt with the Attorney General. And the court pointed out that the Attorney General is the chief legal officer for the state of Tennessee, just like the county attorney is the chief legal officer for Shelby County. And this court said that the majority rule is that the Attorney General or his or her assistants can represent adverse actors in intragovernmental disputes. But, and I quote, when the Attorney General is an actual party to the litigation, independent counsel should be appointed for the state agency in order to remedy the ethical impediment to the Attorney General's position as a party. And we see this repeated in the ESTEP case that I mentioned earlier. In ESTEP, the Claiborne County attorney actually employed private outside legal counsel, and private outside legal counsel prosecuted the overwhelming majority of that case, something the Tennessee Supreme Court did not take issue with. Thus, as the law as interpreted and applied by our courts clearly contemplates, the county attorney, his or herself, is not required to actually participate in every facet of an ouster action. Concluding otherwise would neuter the ouster statutes and really prevent government officials from doing what they are statutorily required to do under the ouster statutes. I see that my time has expired. I'll address anything else if the court has any questions, or tender and rebuttal.
Thank you.
Thank you.
If it may please the court, my name is Darrell O'Neill, and I represent the appellee, Ms. Wanda Halbert, along with my co-counsel, Misty O'Neill. We're here today to respectfully request this court affirm the decision of the trial court. And we make that request for one reason. The trial court specifically determined that they had a lack of subject matter jurisdiction. But before we go down that path, let's start off with a very simple question that 99% of the time Judge Stafford asks me when I come up here. And that is, does this court have jurisdiction? That's the first question. Does this court have jurisdiction right now? And I submit to this court, there's a question that this court does not have jurisdiction. And the reason behind that is, during this process, we filed a motion for attorney fees. Not only did we file a motion for attorney fees, when we filed our motion to dismiss, in that motion to dismiss, we requested attorney fees. To this day, that issue has not been ruled on. For instance,
what statute or what was your basis for the request for attorney's fees?
Two. Number one, we were using 87-47-121. And that statute specifically says that at the final ruling, you cannot receive reimbursement until a final decision. There's a difference between reimbursement and determination, because this court has said that on numerous occasions. Specifically, in E-Solution versus Building LLC versus Connect Strict Contractors, Judge Stafford, you were on that panel, this court said, finding that an order directing parties to resubmit requests for attorney fees after appeal was improperly certified, and holding that because the trial court did not dispose fully and finally of claims for attorney fees, this court lacked jurisdiction. Now, I direct this court to volume 1, page 53 of my brief. And what the court will notice on volume 1, page 53, it was my motion to dismiss. The last paragraph, requests for attorney fees. Volume 1, page 76, my memorandum in support of motion to dismiss. Last paragraph, requests for attorney fees. Volume 2, page 167, the answer to the brief, requests for attorney fees. Volume 2, page 222, requests for attorney fees in the supplemental response. Volume 2, page 294, requests for attorney fees. Numerous requests. And in fact, before this brief was filed, I consulted with opposing counsel to say, I have my motion for attorney fees. will you concede that I will be entitled to my attorney fees if I don't file a specific motion for that issue? They would not concede that point. So if you look at my brief, attached to my brief as Exhibit 1, is a copy of my motion for a request for attorney fees that was never been ruled on. But let's get to a little deeper here. The court said lack of standing here. Lack of standing. The statute is crystal clear. And what we did is challenge paragraphs 11 and 12 of the complaint. And what they did in paragraphs 11 and 12, the court didn't say she was disqualified. She said she was disqualified. Marlinee or Iverson, the Shelby County attorney, said that she was disqualified and could not participate. Well, that conflicts with the statute because you have to have a relator. How can you relate on a matter that you can't participate in? It's counterintuitive. It makes no sense. If you're disqualified, you can't relate. And then we go further, and I'm going to read for the court. I know the court doesn't like us reading to you, but I'm going to read for the court. In the transcripts, and in the transcript during oral arguments, and this is the transcript proceedings on September 17, 2024, Volume 2, page 18. The question, can she then represent herself for the county as the county lawyers? The answer to that is she can't because she had a professional relationship with Ms. Halbert, and as an attorney prior, under the circumstance, she can't act as a representative for the county. So what happens is any other law firms, when there's a conflict, you hire outside counsel to represent. But she's still, now I don't get this, she's disqualified, but she still provides the guidance and direction to me in this particular case. How does that make sense? How are you providing guidance on a matter that you disqualified? Here's where we are. One thing I do agree with counsel is the statute does not have any language about being disqualified. Because what the statute really contemplated was misconduct. You can't counsel a person to commit misconduct. So you can't be disqualified if the person is committing misconduct. That's what the statute was intended to be in place for. And it says everywhere you read this statute is an extreme measure. The ouster statute is the extreme because the citizens have voted to put these people in place. The next one is, can a private attorney represent the county? I think the short answer is yes. That's what East Step did it. But you can't be the only person. What East Step had is they participated. If you participate, because Rule 11 requires you to sign the document saying that everything in here is factually correct. There is no signature from the county attorney. She did not participate. Paragraphs 11 and 12 of the complaint specifically says, I didn't participate. I'm disqualified. I can't participate. But here's the telling part. The one case that is extremely on point in this issue is a case called Jordan. Jordan versus the state. And if you look at my brief and you look at the response to my brief, there is no response to Jordan at all. Can't respond to it. Because Jordan specifically says you can't do it the way it's been done. Undisputed is what Jordan says. And Jordan also explains specifically if the statute says green, it's got to be green. It says the relator has to be the Shelby County attorney. Not if the deputy county attorney could be the relator, you know what it would have been? In relation to the deputy county attorney. That's not how they phrase this. The court wrote a 28-page order. And I know the court has read it and the court will read it. But again, the problem there is it's not consistent. What they're saying they're asking you to do is inconsistent with the statute. The court pre-terminated one of my other arguments was the question is whether or not an agent can do more than the principal. So I know the other issue is if the court determines that this matter needs to be dealt with, that matter would have to be, because it was pre-termitted, and I know this court doesn't like to rule on an initial matter on that particular issue, so that matter was pre-termitted. It was not waived, can't be waived because it was pre-termitted, but as a caution, I actually put it in my brief. Now, the last thing I'm going to say, because I know Judge Bennett want to get back to Nashville, so the last thing I'm going to say here is this. It says that there was an error when she denied the default judgment, because the statute says you can only do certain things. Interesting. But what they don't do in their brief is there's 3 cases in this issue. One of them is Brique versus Yeager, and that was authored by Judge Gibson, who used to be on this court. They don't even address Eblum. Eblum specifically states that you can actually file a motion to dismiss. Eblum says that. I'm sorry, Yeager says that. But I need to read you what Eblum says, because Eblum is a Supreme Court case, which they don't address either. That's because Eblum specifically says, and I'm going to quote what Eblum says here. The court finds that the defendant has undertaken a defense in this case and otherwise defended the case by filing a motion to dismiss within the 20 days period. Eblum went on to say that a respondent may demur, and I need you to understand that because the statute specifically says you can't demur. But what Eblum says is the respondent may demur even though the statute does not allow a demur if no matter how true the allegations, the court lacks jurisdiction. Why would you fight on a matter that the court has no jurisdiction on? It makes no sense. Another example is, it says, if you go a little deeper, we also cite Yeager, which is a 2015 opinion. And what Yeager did, which is interesting, they filed a motion to dismiss. That case came up here to the Court of Appeals. The Court of Appeals said that was acceptable. But here's the most telling of all, and I'll leave you with this one. The most telling of all, they cite extensively Looper. The problem with that is Looper supports our position. Looper goes on to say that Rule 55 will apply, the default rule, which means that you either have to defend or answer. I could have swore that a motion to dismiss is a defense. So we attempted to defend. So the argument that she erred in denying the default judgment, which is discretionary, so they have to establish abuse of discretion, which I don't see how they've done that. So it's for these reasons and the 28-page opinion that the court issued in this particular matter, we request that this court affirm the judgment of the trial court, subject to this court's questions.
Seeing none. Thank you.
Brief rebuttal, Your Honors. To address the issue of attorney fees up front, this one's actually easy for the court. The defendant's motion for attorney fees isn't part of the record in this case. It appears nowhere in the record of this case. It's not before the court on appeal. The defendant did not file this motion for attorney's fees until after the trial court had already orally ruled on the motion in November of 2024, after the appellant filed its notice of appeal, after the designation of the record, and after the order granting the motion to dismiss was entered. All of that is neither here nor there, as the statute actually tells the court why the motion for attorney fees is incognizable here. Section Tennessee Code 847-121. And while Mr. O'Neill alluded to the statute, Mr. O'Neill did not actually quote you the statute, so I'm briefly going to quote it because it matters. After final hearing on the complaint or petition, so after the trial on the merits, any public officer not removed from office, or if the officer has been suspended, any officer immediately restored to office may be reimbursed reasonable attorney fees by the appropriate state, county, municipality, or other political subdivision if either party appeals pursuant to Section 123. No such reimbursement shall be made until a final judgment is rendered. It's also a little curious how the trial court lacks subject matter jurisdiction to adjudicate the dispute, but the court somehow had subject matter jurisdiction to award attorney's fees. Now, Mr. O'Neill also said that the county attorney was disqualified. No one ever used that verbiage. And I believe Judge Corbin Johnson actually disclaimed that verbiage. There was never any insinuation that the county attorney was somehow disqualified in any regard. What
exactly was the county attorney then?
I'm sorry, Your Honor?
What exactly was the county attorney if she was not disqualified?
So the county attorney felt that there might be an ethical impediment to her acting as a lawyer in the case. That does not affect her ability to act as the party plaintiff as the relator. So again, to ameliorate any concerns about confidential information or conflict of interest, the county attorney made the choice not to participate as a lawyer in the case. That has nothing to do with her status as a party.
How was that made, how was the court made aware of that?
Your Honor, that was in the petition that was filed. That's paragraphs 11 and 12 that Mr. O'Neill spoke about. That was also discussed during oral argument, and those oral argument transcripts are in the record. I believe they are September 17th, and then another transcript, I believe, from November, though I can't remember the exact date.
And that specific matter was noted for the trial court?
I believe it was, Your Honor, yes. The county attorney was not acting as a lawyer in this case, and that was part of the trouble that we had down below, was disassociating this notion of acting as an attorney versus acting as a relator as the party plaintiff. That was something that the trial court, I think, struggled with, and I think that's why we ended up where we're at, is there was this inability to sort of separate the two concepts.
And how did the deputy county attorney become involved in this?
So the deputy county attorney is outside counsel, my law firm's liaison with the county attorney's office. Again, to create that wall, that ethical shield between the county attorney, assuming that the conflict of interest rules really bar her from sort of substantively participating, the deputy county attorney is outside legal counsel point of contact for the county.
Is there any concern about someone with a potential conflict, such as the county attorney, being able to select who will act for the county attorney, designate another person to act on her behalf?
Your Honor, I see that my time is expiring, but if I may answer your question. Who the independent, I think the most important thing is whether or not the council is independent. I think this county attorney, regardless of whether the county...
When you say independent counsel, are you talking about the outside law firm?
Outside law firm, like me, Your Honor. Yes, Your Honor. I think so long as, the county attorney has obviously taken steps to mitigate the risk of a conflict or disclosing confidential information, so long as the outside counsel that's selected sort of satisfies that ethical barrier, I don't see anything wrong with that, Your Honor. Any further questions?
No.
Thank you for the court's time.
Thank you. Thanks to all of you. Having reached the end of our docket today, would you please recess us until tomorrow morning?
All rise.
Actually, Mr. O'Neill, the question is,